An offer of immediate counselling to support the plaintiff through the process of reliving memories and enduring the litigation process could have been made. A waiver of the limitation defence, given it was beyond doubt that the allegations were true, and I'll comment further on that later. However, even if the Crown didn't waive the limitation defence, they could have made decisions very early on as to whether an expert psychiatric report was needed, and this be advised to her and actioned as soon as possible. There could have been provision of regular updates, perhaps monthly, of progress on steps the Crown were taking, such as locating documents for discovery, particularly after the mediation. Honesty and transparency in the litigation strategy and advice of steps being taken, including when ministers are involved.
What do you mean by that?
Apparently some of these steps had to go up in cabinet papers to the minister to get approval. So there were delays in that process, approval for the settlements.
But these were unknown to... Unknown to...
There was just this big silence. And a protocol in relation to handling of intimate items could have easily been done and should be done. And I've set out there what that would involve, a register where anyone who's handled that item has to write it down, and it also be returned as copies can be taken of the items, the original returned as soon as possible. Advice, we've taken 18 pages from your diary, they're being held securely for the purposes of litigation, they'll be destroyed afterwards. It's not hard to come up with a protocol like that. When it was evident that criminal activity had taken place, as in Dr. Leake's detention and drug and ECT treatment of adolescents without medical justification, and often directly as punishment, the Crown would have immediately handed the file to the police and fully cooperated and supported the police inquiry, including providing documentation freely into whether he should have been charged. And that will come out later as well, but it's understood that the Crown withheld a number of documents from the police when they were investigating whether to charge Dr.
When you
Leakes.
say later, you mean in the full inquiry?
June inquiry. Crown Counsel would and should have told the plaintiff what part of the monies came from Dr. Leakes, and if none of them came, she should have known that and had the chance to reject the settlement. And there was another issue relating to Dr. Brinded's report. After she had her psychiatric assessment, it was done under Section 100 of the Evidence Act and should have been filed in court because it was actually a property of the court. 5 months later, Philippa had asked about 4 times, and you can see it in the documentation, it still hadn't been sent to Leonie, who was most anxious about that report. So looking...
I'll take a breath, please. I'm receiving messages that speed is just too great.
Thank you. I'll take a drink. Just discussing the Crown evidence now. So there's only 2 witnesses that Council has.
I mean, this is the Crown evidence given
by Mr. Knipe
in this hearing.
In this hearing,
yes.
By Mr. Knipe and by Ms. Jagos. It was disconcerting to hear Mr. Knipe, Ministry of Health Chief Legal Advisor, explain that he had written something up for the website 3 years previously, but had not got through communications at the Ministry of Health. This was advice as to how Lake Alice survivors could make a claim to the Ministry about their treatment. This appeared to be a sufficient explanation for him as to why there was no publicity on the Ministry of Health website. And he didn't seem to think that there was anything to worry about. He did undertake to try again to get that information up there. It was also disconcerting to learn there'd been no attempt within the Ministry ever to actually make a list of the children and adolescents who'd been in Lake Alice in the Lake Alice Child and Adolescent Unit, to contact them to see if they were okay and to offer them compensation. Mr Knipe had not seen the need and noted it would take up too much clerical time. Given the horrors of what went on, that was public knowledge within the ministry since the Gallen report, it's disturbing that this was not done 2 decades ago and is still not being done. In relation to the Solicitor General's evidence, she has still not seemed to properly grasp that her office has failed abysmally in its duty to advise its client, the government, about its human right and totality duties to the survivors and to work proactively to develop appropriate redress systems. Instead, it allowed itself to become locked into an aggressive, punitive, heartless litigation strategy to block claimants from any monetary compensation at all. That they had a solid, provable case was irrelevant. Mr White and Mr Whiffen were the immediate victims. The tactics were clearly intended to threaten and intimidate other survivors and their counsel, Cooper Legal. Those waiting in the queue were the later victims, now forced into alternative settlements with pathetic amounts of money on offer. It was suggested by the Solicitor General that if you go down the litigation path, you have to know what you're in for, and it's tough and rough. With respect, that is certainly not an inevitable consequence of adversarial litigation. It's a basic duty of all litigation lawyers to continually review whether the matter can be resolved without going to court. There's not 2 totally separate streams. You constantly are looking at, should this case settle, is it in the client's interest? You're constantly balancing up the pros and cons. And it's certainly a duty to be polite and respectful towards your opponent and your opponent's client. But all legal means available were adopted to bar genuine claims. A discretionary legal defence, the Limitation Act, was used routinely with vigour to stop victims of major rights abuses from gaining any traction in the courts. The irony of this being that the reason the claimants were out of time was because of the nature of the impact of the abuse upon them. Abuse that happened to them while their client was caring for them in loco parentis. It's regrettable to say that the Behaviour and Crown Council, in using all its available defences against these vulnerable people, fits the description of shameful.
Mr Joychild, what would you say to the proposition that, knowing that the irony, as you pointed out, but that at that time, back in the early 2000s, the myths and the knowledge of the myths about survivors, their responses to sexual abuse wasn't so great, and that what was happening was just done out of ignorance? I mean, you were saying here that there was a deliberateness about this.
There was a deliberateness about it. The Crown, in the general community there may have been that ignorance, but the Crown is the client of the government and advises the government. It has a number of human rights commitments at that stage. The Convention of Elimination Against Women talks about sexual matters.
I don't think it's elimination of women.
Oh, it's elimination of discrimination against...
Sorry, CEDAW.
CEDAW,
Yes.
CEDAW, UNCROC, Children's Convention, DRIP, that's come later, the Declaration on Indigenous Persons. The Crown should have been the people who were least ignorant of all of these myths. And they also saw the evidence. There was a lot of information around certainly in the 90s, let alone the 2000s. It was public knowledge that, I can't off the top of my head talk about criminal law, rape case law, but certainly the recent complaint evidence was being criticised for 30 years. I recall it being criticised when I was at law school. The Crown should have known. Should have known it was its duty to know. So at paragraph 51, it submitted the default position of the Crown Law Office should have been to waive the limitation defence with a discretion to use it in appropriate cases. Of course there's good policy reasons for a Limitation Act. No one's got any issue with that. But they don't apply well in this case when the reason for your disability is the very act of which you're complaining. And another point, why did Crown Law Office not see the blindingly obvious truth that if hundreds of complaints were coming in, there must have been major systemic failings in the care and protection of children and young people in care? They should have had the wider view. Once again, this tunnel vision, oh, well, there's some in Koiteri and there's some here, but there's none of them everywhere. That's just beyond belief. There was a systemic problem, and there was a lot of violence, but a major part of that problem was paedophilia. My clients have told me that in every institution there would have been 2 or 3, and while a lot of staff were great, you've got 2 or 3 preying on young boys in the evenings when the lights are out. Routinely, nightly, preying on boys. So there was a massive misunderstanding, or even where it was known, not dealing with the issue of paedophilia. And of course there are lots of things you can do around that to protect children now. If the Solicitor General thought the litigation process was inappropriate for historic abuse cases, as she's now saying, then why did she fight so hard to retain it over years and years? Why did her office resist the 2004 Attorney General's request and Cooper Legal's request, which I understand was 2010, to discuss and develop an alternative process? The evidence also disclosed many extraordinarily unfair attitudes towards Cooper Legal. For goodness sake, where else could they take the claims of their clients if not to court? Under our Constitution, the court deals with breaches of rights. That was the place to go. Unless she is saying Crown Counsel believed those clients did not have rights to seek redress for abuse while in state care. This does seem to have been the attitude. Crown Counsel were going to drive the cases out of the courts and into oblivion because there was no Plan B. Plan B developed after the White case, but the plan, and because of the persistence of the lawyers articulating for their clients, the survivor clients.
Plan B being the ADR process.
ADR process. There was no thinking, this is the inappropriate place. The whole strategy was to make these defences work so that we had, you know, limitation working against them, ACC working against them, proof, factual proof working against them, and then they're gone. Then there's 1,100 cases we don't have to worry about. Cooper Legal were criticised for filing cookie-cutter documents. With respect, if you're a legal aid in receipt of legal aid as a lawyer and you have hundreds of cases to file suddenly after discussions on an alternative process have again broken down, then, so as to protect your clients against litigation claims, you will use templates for some of the claim. You have no other choice. Also, you'd be heavily criticised by legal aid for spending inordinate hours at that stage on highly specific claims. That can come later, but you need to get your claim into court to stop the clock ticking on the limitation point. The aspersions about Cooper Legal being motivated to seek a settlement for a client so as to gain another income stream are completely unfair. Cooper Legal were doing the right thing, trying to resolve the case outside of court. The comments also show ignorance on the part of Crown civil servants as to how money is earned if one is not on a salary. For the record, there are staff to pay, and Cooper Legal have staff, taxes to pay, experts' expenses to pay, travel costs to pay, office rent, other office expenses, ACC payments. Senior counsel undertaking legal aid earn $149 an hour with caps on the number of hours.